to lay out the processes following an individual's extradition. We're now joined for legal analysis by legal expert Mpumelelo Zikalala. Very good evening to you. Thank you so much for your time. I mean, we've just heard that Cholota, under the escort of the SABC and Interpol on a plane, has now landed in Johannesburg this evening, of course, bringing together a case that needs to evolve now with the different people involved in it. What are the next steps as she lands in South Africa?
Probably immediately after landing, she would have been charged, which is why they're taking her to a police station. And after that, the rights that accrue to her, as Section 35 of our Constitution, are then being exercised. So she must be informed why she's being charged. She must then be available or have access to a legal representative. And probably during the week, probably on Monday, or maybe Tuesday, she will then make her first appearance. And once you do that, then you go to court and they also explain your rights to you. That's when you get an opportunity to apply for bail. And that's when the Criminal Procedure Act will then kick in, specifically or specifically to note Section 60, which then deals with the bail application. So I may anticipate that during the long weekend, her team, if she does have a legal team, will be hard at work in terms of drafting those legal papers, making sure that by the time Monday comes, they are ready to make a comprehensive bail application in which they would show to the court why is it in the interest of justice that she be released on bail.
From what we understand, that from June, the Maryland District Court Magistrate Judge Aaron Aslam had ordered Moroadi Cholota to remain behind bars up until U.S. Secretary of State Antony Blinken decided whether to authorize her extradition. What exactly does such a process entail? The many layers and steps that are needed, which have essentially resulted in her landing in South Africa this evening.
Remember that South African law enforcement agencies would have relations or would have forged relations with other foreign law enforcement agencies. So in this case, they would have had an agreement with the US and Interpol to say, if there's someone that we so desperately need to come back to South Africa so that they can be able to answer to their charges, can you be able to effect the arrest for us? That means arrest them and detain them up until they are then be able to come back. But once you do that, please give us the assurance that the manner of detention is going to be one which is going to be humane. There are not going to be any human rights which are going to be contravened, and you are simply doing so for the sole reason of having to secure that individual so that they come back. So that is why we would have found that the extradition application was first made in the US, with the South African authorities putting out a formidable case to say, here's the prima facie evidence that you are going to present in court. There is merit in what you are representing, and there are merits in what the accused must come back and answer to in South Africa. So on those basis, please effect this arrest, detain her, and when the time is right, they can then come back to South Africa. Obviously, within that particular country in which you are detained in, you are going to have an opportunity to put up your defense, as I assumed would have happened in this case. However, if those authorities or the presiding officers of the opinion that you must be extradited back to your country, that's exactly what's going to happen. And I think in this case, the South African government have put up a formidable case, and has certainly shown how these extradition applications ought to be done, so that you do not leave anything to chance, and you make sure that you provide all the evidence which is required, because the last thing that you want is your extradition application to be denied simply because you did not do enough homework and put up evidence which is going to be able to persuade the presiding judge in a foreign country that you really need this individual to come back to South Africa so that they can be able to face their charges.
Perhaps in getting to understand the depth and the layers of this case, according to court papers that had been filed by the Free State Director of Public Prosecutions, up until the state had met with Cholota in the US in November of 2021, the NPA at the time was of the view that she was a state witness, up until she allegedly now made an about turn and failed to cooperate with the state. What kind of predicament does that place her in the eyes of the court, and as she is now accused number 17th?
Remember that in the eyes of the court, she's just simply that, an accused, and there's a blank slate in which the information will have to be filled in by the state, and she will have to rebut it with the information that is going to be provided. So all the background activities that have taken place are not really significant within, especially within the trial stage. They may be significant within the bail application stage, in which maybe the argument from the state would be, she realizes the importance or the toughness of the case that she's about to face. Hence, it's important that she will not be granted bail if they so oppose it. However, those things that have taken place prior to her arrest are not going to be information that is going to be relayed at a later stage. You may even find that she may find a legal rep who's going to say, well, let's enter into a plea and sentence agreement. You assist the state, and once you've done that, you'll get a much lesser sentence. We'll come back and say, at the time in which you're being advised or in earlier negotiations, you are not represented or you're given information which was not really conducive to you. Or after seeing what have taken place and the evidence that is against you, you've taken a view of saying you do not want to waste the court's time and you want to cooperate fully. So we must separate those two instances. Yeah. They may not be important for trial, but may be important for the bail application.
I mean, the reason I asked you that question, Mpumelelo, is because the Cholotas legal team had argued that she was charged with multiple counts of fraud, corruption and money laundering, primarily due to her refusal in questioning as a state witness to attribute specific actions perhaps to her former ex-boss, Free State Premier Ace Magashule, and not because she was implicated or even had committed any of those crimes.
That may be a defense, but it is a defense in which you'd have to ventilate when the trial is started, to say to the state, what evidence do you have against me? Give me an opportunity so that I can be able to refute it. Depending on her role and what her specific activities were, and maybe in following the money from the time in which the money was paid from the government coffers to where it landed, you may find that she may be on the right to say, all I was doing was to be a personal assistant, and that's where it ended. If there are any specific roles that she might have played, then it's up to the state to say, here we are coming with the evidence, we are going to make sure that you come back with the conviction in this case, and the type of examination that you are going to come with is going to say to the court, believe us rather than believing anybody else, and if you do so, make sure that you convict this person of the crime that is alleged that they have committed.